So yes, I am Kay Warnock. I am NCSL's liaison to the Legal Services Staff Section. First, a little bit of housekeeping. I just want to let you know that during the presentation, if you have questions, you can post those in the chat box that's in the lower left-hand corner of your screen. So you can just go ahead and post your questions there. We'll be taking the questions at a midpoint and also at the end. But if you have questions and they pop in your head, it's okay to type them there and we will get back to them as soon as there's an opportune moment to do that. I wanted to let you know that this webinar is sponsored by the Legal Services Staff Section and is supported by an NCSL e-learning grant. There are over 80 registrants from 27 states and the District of Columbia participating today. There are no formal handouts, but if you click on the media library icon on the upper right-hand side of your screen, you can download a copy of this PowerPoint presentation. And then if you have any questions or anything, our contact information both for our presenter and for me are at the end of this presentation, and we hope that you'll let us know if you have questions. Also, we'll be sending out a survey for you to give us your thoughts about this webinar and to tell us what webinars you'd like to see in the future. Our moderator today is Wendy Jackson. She is the Administrative Services Manager with the Legislative Reference Bureau of the Wisconsin Legislature. Wendy is also the chair of the Legal Services Staff Section. Welcome, Wendy.
Thank you, Kay, and hi, everybody. It's my pleasure to welcome everyone to this webinar, Client Interactions for Legislative Drafters. This is the first webinar in a new series of online programs that the Legal Services Staff Section will be producing in the next conference year. And on behalf of the Staff Section, thank you all for tuning in. It's also my great pleasure to introduce my colleague and our esteemed presenter today, Tammy Dodge. Tammy is a senior legislative attorney at the Wisconsin Legislative Reference Bureau and an expert bill drafter and client interactor. She drafts in the areas of gambling, health, medical assistance, and public assistance. Tammy is a staff vice chair of the NCSL Health and Human Services Committee. In addition to her work for the legislature, Tammy is a competitive ballroom dancer, and she is an arts connoisseur. Thank you, Tammy, for presenting this webinar today, and I now turn the floor over to you.
Thank you, Wendy, for that nice introduction. I'll get going with my slides, and we will start with a quote by Maya Angelou, because I think more attorney CLE should start with a quote by Maya Angelou. And she said, "I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel." I think that's a good start for the day, because today we are talking about client interaction. So first, a story. Before starting to work for the Legislative Reference Bureau as a drafter and before going to law school, I was a defense-side litigation paralegal. Being a paralegal is somewhat similar to being a legislative staff member. Often you don't have a lot of say in what the final outcome is going to be of the product. You answer questions when you're asked, and when an attorney says to jump, a paralegal says how fast and how high. This team of paralegals that I was on was doing work predominantly for a single client and worked with a team of attorneys. Attorneys, like legislators, come with various personalities. Some are chatty and chummy, and some are technical and very serious. There was one attorney, Jim, on the team that other paralegals really didn't like to work for. He came across as abrupt, serious, intense, stern, maybe even rude. The paralegals who preferred to chat about families and their weekend plans didn't really know how to deal with Jim. But I considered it a personal mission to get along with those whom others do not. Of course, this is within reason. So I decided to observe and then let Jim's actions tell me how it is that I'm supposed to deal with him. So Jim would be in my office, full of nervous energy, fretting about deposing an expert. This expert works for NASA. What am I going to do? And at one point or another, Jim would be muttering about a tough judge in Cook County where you had to start arguing before you even got out of your chair. And then another day, he was prattling on about making sure he had his green tea remedy to calm his stomach. I came to realize that Jim is not really abrupt or rude. He's terrified. His singular, all-consuming goal was to do as well as he could for the client, messing up was not an option for Jim. So if you wanted to get a smile out of Jim, you didn't talk about kids or social events, that wouldn't help him get to his goal. You walked into his office and quickly said, here's what you asked for. Briefly, here's a summary of what I found. Now, is there anything else I can do for you? I can get you whatever you need for this case. To that, Jim would grin and say, thank you very much. Thank you. So today I'm talking about interacting with your client, the legislators in your state, and fulfilling the unwritten job duty of being a legislator whisperer. To do that, I'll use a framework of the model rules of professional conduct for attorneys. Now, this is not a discussion of applying those rules directly to staff. I don't know whether or how your Office of Lawyer Regulation applies those rules to legislative staff, and quite frankly, I don't care. That's not the point. The point is providing the best, most efficient, and effective service to legislators. And if you want to think about how to do that or improve what you are doing, these model rules contain a starting point for thinking about that. And so here's the perspective I'm coming from. Wisconsin has 132 legislators, which is 99 representatives and 33 senators. Our legislators have their own staff, or at least one staff member, and I just learned at an NCSL conference that this is not always the case. Some legislatures do not have individual staff members, but ours do. So when I say legislator, in some or maybe most cases, I'm actually referring to the legislator's office staff, whom we deal with most directly. But sometimes we do deal directly with the legislator. Wisconsin's Legislative Reference Bureau divides drafting responsibilities among about 22 drafting attorneys by subject matter, and Wendy already went over mine. Mine deal mainly in the areas of health and how to pay for health, and of course, just with a little gambling thrown in. So while that means I have a relatively small universe of legislators that I deal with regularly, most of our drafting requests are actually done through communications that aren't in person, such as office staff, on the phone, or maybe over email, which I think can be a detriment to interacting with your client. So now that you know what perspective I'm coming from, I'm going to cut straight to the bottom line. I'll start at the end goal. Generally, the best way to improve any attorney-client relationship is to build trust. My working relationship with Attorney Jim, who I was talking about before, was greatly helped because he could trust me to do the work quickly and thoroughly and not to waste his time, which was the important part. A trusting relationship can also have some benefits to you as a drafter in the long run, and we'll see that a little later. As Stephen Covey, the author of The 7 Habits of Highly Effective People, said, trust is the glue of life. It's the most essential ingredient in effective communication. It's the foundational principle that holds all relationships. And I won't disagree with that. So how do you build trust? Well, the rules of professional conduct can help create a framework for how to start building trust. And let's start with competence. The model rule of professional conduct, and I will say that, like for example in the state of Wisconsin, we've adopted our own rules of professional conduct, which are very, very similar to the model rules, but I'm using the model rules, of course, because they apply in many states, or at least you can just use them as kind of rough concepts for these ideas. The rule of competence is that a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Obviously, in our world, this sometimes depends on the time we're given to answer a question or prepare a draft. But, I mean, having competence really goes without saying. Legislators depend on their staff and nonpartisan staff to be the issue experts. And they want to be able to rely and trust our expertise since they don't have the time to become experts on every issue themselves. Now, competence doesn't mean that you have to know everything off the top of your head. You do, however, have to know when you don't know something. I think it's perfectly okay to say, I don't know, but I'll look it up and get back to you, and then do that. Competence then goes hand in hand with another rule of professional conduct, diligence. It doesn't really help your relationship with a legislator to say, I don't know, that's not my area, and just leave it there. It's not my job, go figure it out. Because you left the legislator or aide with the task of figuring out how your office is organized. And sometimes I don't even remember who drafts what in our office. So what you can say to the legislator is, sorry, that's not my area, but I'll track down the right person and have them contact you. Make sure you do that promptly. Make sure they follow up promptly. That's diligence. Diligence, the rule being a lawyer shall act with reasonable diligence and promptness in representing a client. Remember that legislative staff has time to develop expertise, which then saves time for the legislators who may be brand new and may only have 2 years to serve before running for election again, or in some states, not Wisconsin, but in some states they're term limited, so you have a brand new crop of legislators coming in all the time. Diligence is related to another rule of professional conduct and probably one of the most important concepts for developing a trusting relationship. And that is, ta-da, communication. This is part one. Communication is so important, I'm going to talk about it twice. First, I'll talk about it more generally. And so this is the first portion of the model rule. It comes in 2 subsections, if you will. And it starts out, a lawyer shall promptly inform the client of any decision or circumstance with respect to which the client's informed consent is required. Basically, get the necessary information you need. Number 2, lawyers shall reasonably consult with the client about the means by which the client's objectives are to be accomplished. Figure out what it is the legislator wants. The last 2, I think, are the most important points that we have to remember, and that is a lawyer shall keep the client reasonably informed about the status of the matter and promptly comply with reasonable requests for information. A legislator is not going to trust you if when they contact you it seems like the request falls into a black hole of silence, only to appear at some point in the future that the legislator can't predict. Communication is so basic and important that I really just want to say, well, duh, and leave it there. But for the sake of this webinar, I'll elaborate a little. Sometimes communication may be a little painful. Sometimes you may have to suck it up and fall on your sword when times get tough. But here, I think permission is better than forgiveness. I really can't think of a time that I've been put on a legislator's naughty list. If I've had to call an office and say, hey, this week went really south and I'm working on what you want, is it okay if I get it to you Monday instead of today? Most everyone says yes if they have the ability to do so, and they aren't really upset by that. They're happy to know that whatever they want is on its way. The staff member just needs to know if the legislator is asking them where that thing is, where it is, and you hold that information. Being upfront and actively asking about deadlines and expectations then is important too. If they've scheduled a press conference or are coming up against that floor period or committee hearing, they won't have a flexible deadline. That is important to know whether that deadline is firm or flexible. Don't bother asking for an extension if that's a firm deadline. Here's where a history of communication and building trust matter and can pay off for you as a drafter. If you've developed a history of getting things done competently and on time or early and communicating with the office, they will be more willing to give you a little break if you need it. Try not to need it, but life happens. It's just human nature to be more willing to put in more work for someone who's kind and respectful. If I think about it, when someone asks very nicely for me to do the impossible, I'll give it a try. But if they're rude, the impossible looks just, well, impossible. Another aspect of building trust, especially in a nonpartisan context, is confidentiality. The model rule relating to confidentiality isn't really helpful in the legislative context. It deals mostly with the traditional attorney-client relationship. So I've provided an excerpt of the comment to the model rule, which you're welcome to read. That doesn't really diminish the importance of confidentiality, though. Generally, in our office in Wisconsin, drafting records are confidential unless the office explicitly waives confidentiality, like, for example, asks you to share the draft with a co-author, for example, or someone specifically. Here in Wisconsin, those drafting files become public once the draft is introduced and becomes a bill or an offered amendment. Confidentiality goes a long way in keeping the appearance of nonpartisanship. And being around politics, we know that sometimes the appearance of something is really everything. A nonpartisan staff friend of mine who I met through NCSL said as nonpartisan staff were walking a line, and then he made this hand gesture of a balance beam that's about 6 inches wide, that over time seems to be getting narrower and narrower, and now it feels like we nonpartisan staff are walking on a tightrope. So we are the poster children for representing clients who have a conflict of interest or dealing with people who have a conflict of interest. The best way to walk this tightrope is to do the best job possible for each legislator regardless of party. Crucial to that is confidentiality and knowing that you, as nonpartisan staff, won't reveal one side's strategy to the other side. Again, this is about trust. As an illustration, this new age of social media has led to some interesting side effects I've noticed. I was at a dinner with a group of people, and one woman kept taking selfies, with the rest of the table in the background. Her husband got up to dance. He's not a dancer. Got up to dance, and she was taking a video of him, and he wasn't aware that this was happening. So I kind of made a mental note of myself not to spend a whole lot of time with that person. If I'm chatting socially, I don't really want to have someone taping it or posting it to Facebook or even just taking notes on it. I prefer to have conversations with people focused on the conversation and not the broadcasting of the conversation. I know that makes me old-fashioned, but that's the way I am. I have a feeling that some other people are too. But the point is that when I'm around this social media maven, I'm going to double check for recording devices, and I'm probably not going to share very freely with her. So think about this when talking to and meeting with legislators. So I have a couple of points on communicating in person or in meetings. First is the issue of appearance of confidentiality. Legislators may tell you things kind of just to be helpful to realize the urgency, emphasize where they're concerned about the issue, and what their general position is on the issue. They kind of want to believe that even if you aren't on their side as nonpartisan staff, that you're a member of their team in accomplishing their goal. But they might not want everything they tell you memorialized for posterity for risk of escaping into the, quote, enemy hands, end quote. So even though your notes might not fall into the wrong hands, the perception is that they could. So be judicious about what you need to scribble down. Of course, that means if you aren't scribbling notes, you may need to make eye contact, which leads me to the second point. An important aspect of competent and effective communication is tailoring your communication to your audience. And part of determining who your audience is involves watching their body language. If you're staring at your paper, perhaps frantically taking notes, you can't watch the meeting participants and get a sense of their true opinions. I've been in more than one meeting where a lobbyist is talking, but it's clear when you look around the room that no one really cares, and the legislator really doesn't intend to use this suggested as part of the bill. They're just letting the lobbyist talk to make the lobbyist feel included and heard. Furthermore, it is difficult, unless maybe it's only me that's not this talented, but I can't write and talk at the same time. So if you're in a meeting, you might not intend to actually be giving any input, but if you're writing and not engaged, you don't even look like you could give input if they ask you a question because, well, you're busy writing and maybe they don't want to interrupt you. So you look more like the meeting secretary instead of an attorney with expertise. So what I'm saying is look engaged, be engaged, and pay attention to the room. I draft in some controversial topics. So I've been invited to meetings with legislative offices and lobbyists where it's clear that providing drafting instructions is not the only goal. It's more a meeting to get other parties, I'm going to call them stakeholders, even if, I can't stand that word, on board with the language. Sometimes I won't even take out a writing utensil or something to write on. Won't even take it out of my bag. I think this encourages the participants to speak freely and allows me to focus on listening to what it is that they have to say. So I'm not saying don't take notes. Take notes when you need to write down a particular instruction. But consider trying concertedly to just listening or contributing the rest of the time. And now, since we're on a webinar and I can't see you, I'm guessing that some of you that may have been taking notes have now stopped. And I also realize the irony of talking about interaction, not a medium that I can't easily interact with anyone. If you could see me, you would notice that I am talking with my hands, but of course you can't. At this point, I will take any questions that people have before I move on to some more specifics.
This is Wendy, Tammy. There is one question, which is there actually an attorney-client relationship formed between an attorney working for a nonpartisan legislative office and individual legislators?
That is like the $25,000, $60,000, $1 million question. That is one of the main questions, and we've been debating that for forever in Wisconsin. I believe there is an attorney-client relationship. I believe we work for the legislator as through individual legislators, and that there is then not the traditional attorney-client relationship, but an attorney-client relationship, especially as it relates to confidentiality and being competent and diligent for that particular legislator. I will say that for a lot of these concepts, while I'm working under that assumption, it's not really even necessary that there be one, as long as you're recognizing that providing a service to the legislator or legislatures, whichever, can still be informed by these rules. Are there any other?
There are not at this moment, but I would remind participants that you can please use that chat box to the lower left-hand corner of your screen to ask Tammy questions. Thank you.
Okay. Seeing no more questions pop up, I will move on to more specifics about drafting instructions and how the model rules can inform how we kind of deal with the details of our day-to-day job. And I know that just having a question on attorney-client relationship, and now you see scope of representation on the screen, and now you're probably really wondering why. This rule really doesn't relate specifically to the legislative staff context, but it can still kind of inform, or at least it can give you something to think about how you work. Scope of representation is kind of the question, or the answer to the question that I'm asking myself when sitting at my desk. And I pick up a file and I go, now what am I doing with this draft? So to start out, the first part of the rule on scope of representation is that a lawyer shall abide by the client's decisions concerning the objectives of the representation and shall consult with the client. And that's really basically they're kind of in charge. It's their bill, and we have to find out what it is that they want done regarding their bill. The last point, C, is that a lawyer may limit the scope of representation if the limitation is reasonable. That really isn't as applicable to us because, well, they're asking us to draft a bill for the most part or answer a question, and that's kind of what we have to do. But every once in a while, there'll be those moments where someone will ask for something really, really big, and in order to get them something to work on, you might say, can I just get you this piece for now, and I'll work on the other part of it later. So while you're not really limiting what their bill is going to be ultimately, but you might have to just, give them some reality as to how long some things take, because they don't know how long some of this takes, and some of it that seems really easy takes longer than they would expect. I would also note that the middle point, which is a lawyer's representation of a client, does not constitute an endorsement of the client's political, economic, social, and moral views or activities. Really, that's a description of being nonpartisan. I found it actually just interesting that it was in here, but it's also something to remember as you're drafting those controversial topics, that this doesn't say anything about me, but I still have to do as good a job as I can for the legislator. So something to just remember every once in a while. So scope of representation here, I'm really just relating to the scope of a request. And defining the scope of what you're doing for a particular legislator is critical to effectuating their intent and having a satisfied client. If the legislator thinks I'm just making like one little tweak to one little statutory section and they're expecting a bill that's going to be less than 5 pages, they're going to be really unhappy when it's like 60 pages long because I decided to reorganize the entire chapter while I was there. If I okayed that with them ahead of time, even if it was on my own instigation, that's okay. But if they just get this without me telling them that ahead of time, that might be unwelcome. So setting the scope really dovetails with communication. It can be important to reiterate what it is you think your task is. I do this often at the end of a meeting. I'll recap what they should expect to receive from me, even if they won't be receiving anything because I'm waiting for them to resolve an issue. I actually state that. Also, summarizing the drafting instructions out loud sometimes can point out to them some red flags. Some things are perfectly good ideas on paper until you say them out loud, and they might notice something that they want to rethink when you reiterate what it is that you're doing. Going along with that is a concept that I call setting the default. I do this sometimes if I'm emailing an answer to a question, where if I can't move forward with a draft until I get an answer, I'll tell them that by saying that, well, I'm putting this draft on hold and pending your response. You won't get anything until I have this answer. That type of thing. Because I think the worst conversation is having someone call up and ask where their draft is, then have to respond that, well, I'm waiting for you to answer the question. And then there's kind of this moment of, oh, and that's kind of a communication breakdown and kind of a waste of time that wasn't supposed to be, that we really don't want to go on. So also if I have a time crunch where I really want an answer to a detailed question, but it won't cause the whole draft to come crashing down, I can get a draft out. It's just I need this one point decided. Sometimes I'll say, if I don't receive your answer by, say, 8:30 in the morning, I'll draft it this way, and we can change it later. This way we can both move forward with our work. They know what I'm doing. They also know they have that option of answering that question and getting into the draft if they get it in soon enough. Again, this is defining the scope, and guess what? Communication. Again, part 2. This is the second part of the communication rule, which is that a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. Sometimes really explaining might not be what we're doing. We just might be trying to get more information to complete what it is we believe is the intent of the legislator. Because sometimes there are gaps in those drafting instructions. So how do you fill those in? One way I do it, and this might be a really strange way, is that if you know your audience, sometimes you can fill in the blanks just by kind of mentally stepping into their shoes and predicting what it is that they would want. Then you can ask them if your assumptions were correct. Now, it requires paying attention. It also requires a little humility, because sometimes you'll have to admit that you were way wrong, which is fine, as long as you're willing to do that. And I realize that makes some people uncomfortable. I do this because I prefer to have something in writing as a jumping off point. but that can be risky. Another version of this is to start with an existing statute from your state or another state to start the discussion. And then you can at least say where you started from without feeling like you just made it up. You may also be able to fill in gaps using outside sources like the legislator's own press releases, but be very careful here. There are some caveats to communication that I will discuss in what I'm calling filtering out the noise later in this presentation. So sometimes you just have to get more information from the requesting legislator or his or her office. Now, I prefer meetings, and phone conversations can also be useful if the office can give you the answer themselves without checking in with their stakeholders. And note that there are ways to ask a question to kind of manage the response. And I don't mean to direct the policy choice, but to get them to articulate their policy choice. To do this, you have to manage your writing, mostly by controlling the length of the question and the tone of the question. First, we'll talk about brevity, and I hope that will be briefly. In Wisconsin, we have in our drafts embedded notes in preliminary versions of a draft where we can ask short questions about a particular provision, such as, I made this provision, a violation of provision, a class I felony, just like this violation in another section. If you want a different class of felony, please let me know. These notes tend to be shorter, which helps encourage the reader to get right at answering. They're also in context in the draft, so you don't have to explain too much about what you're talking about. But when faced with putting questions in writing outside of this, length can be your enemy. The first hurdle to answering a question is, well, reading it. And I admit I'm guilty that if I get an email that's a sentence long, I'll read it and I'll probably answer it right away. But if I get a really lengthy email, I'm afraid it's complicated, so I'll set it aside, maybe after groaning and muttering, really? Seriously? So if you don't want to elicit groans when your written communication arrives, in private practice, I remember hearing about the judges who would read the first 10 pages of a brief and then stop. If you didn't persuade them by that point, they were annoyed and they weren't about to be persuaded by you anyway, no matter how long after that you went on. So I realize I stressed competence, but I don't believe you demonstrate competence by sending a long-winded dissertation with all you know on the subject for them to wade through. That way you're only demonstrating really your ability to write a lot of words. Part of competency, I think, is the common sense to realize when you're taking the reader's time unnecessarily. I once saw a quote once, and I love it. It was something like, knowledge is knowing a tomato is a fruit, but wisdom is not putting it in a fruit salad. Which is, and I'm looking for wisdom here. Think street smarts, not book smarts. In private practice, I was told that if you cannot summarize your case in one pretty short sentence, then you don't understand your case well enough to present it to a jury, and you need to spend more time with it and understand what's going on. And this concept is embodied in this quote by Blaise Pascal, which is, I have only made this letter longer because I have not had the time to make it shorter. So I'm urging you to take the time to make your questions as concise as possible, perhaps even laying out a summary of the issue and then offering a more depth discussion if the legislator desires, but then not throwing all of that at them all at once. Basically, write enough to get an informed response. This may also mean that your writing needs to pack a little more punch than the typical passive legal writing style that they sometimes teach you in law school. As FDR stated, be sincere, be brief, be seated. That doesn't mean you should sacrifice the appropriate tone. The Chicago Manual of Style suggests that editors, when communicating with authors, follow this rule. A query must never sound pedantic, condescending, or indignant. I particularly appreciate this quote because it actually sounds a little bit pedantic to me, but be that as it may. I think that it's a rule that should generally apply to any professional communication with a legislator, with coworkers, whomever. Basically, this means to make your question understandable to the reader, considering that the reader may not be a lawyer or might not have your particular expertise. A legislator who doesn't give explicit instructions is probably just asking for help in filling out the blanks and doesn't know the possibilities of what can even go in those blanks. If the legislator could fill in the blanks, they may have done that already. So the legislator is looking for your expertise and assistance. The key word is assistance. They don't want to be talked down to as much as anyone else does. The style of a question may help with tone here. Help the legislator feel like he or she knows what he or she is doing, even if he or she really doesn't know. Let's take an open-ended question, for example. In conversation, how are you, how's life, are perfectly fine because, well, people are usually experts on their own lives. But an open-ended question to get more drafting instructions may lead to an awkward silence. If the drafting instructions have gaps and the question to the legislator is, well, could you give me more information on this request? It might not elicit helpful information. The legislator may want to know just what type of information that you need from them. So consider maybe checking out a program in current law and stepping through the parts to see what the legislator may want in this new program at each part. Like, for example, for a grant program. Do you, Mr. Legislator, want to say who's eligible, or do you want the department to decide? How much do you want for each grant? This leaves it in the legislator's hand without facing a daunting, open-ended question like, could you provide more information about what you want in this grant program? Leading questions, I think, are perfectly okay. Something like, do you want a criminal penalty, like a Class I felony for this, like a similar provision has, as opposed to, do you want a penalty? Multiple choice questions are good ideas too. Now, sometimes this doesn't work. I know that I have asked, would you like X or Y? And the response is, I'd like 12. Totally nonsensical, but it's worth a try. And be careful, not to imply through a question that their idea is poorly thought out or crazy. It's difficult when faced with drafting instructions that are kind of a tangled mess of verbiage in search of an objective, but resist the urge to blame the messenger for poor writing. Don't say, well, your instructions are so unclear that I couldn't draft this portion. Perhaps try playing dumb. Gosh, I'm just not understanding what you want here. Maybe you can explain it to me again. My brain's foggy, or somehow I'm just not getting it. It gives them the opportunity to save face. Sometimes, to get the right tone, you might have to write something down and then put it away for a while and come back at a different time to reread it. Maybe have a coworker look at it. Wisconsin has legislative editors, like Wendy. And maybe ask an editor to check the tone of the writing and see what they think. See if it comes off a little bit indignant or condescending to them. It is possible to be emphatic and definitive without being pedantic, condescending, or indignant. Or maybe there are some days that even in a pinch, go ahead, write that pedantic, condescending, and indignant email, look at it, then hit the delete button and start over. I will say when doing this, make sure to delete the to box so you can't accidentally send it to someone, or you could, I suppose, send it to yourself. Can you tell I've used this angry email that I don't send strategy before? What happens, though, when you have to give the bad news? And I'll just pop the communication rule back up here again. To fulfill this concept embodied in the rule of communication, sometimes we have to provide bad news, or at least bad news from the perspective of the legislator. Now, I try not to look for problems with an idea. The legislator is a co-equal branch of government and can make laws even if a court later strikes them down. That's my perspective, so I try not to search for why they shouldn't do their draft. But if I see that pothole that the legislator is about to unwittingly fall into, I feel I should, as a legislative attorney, let them know gently. The question becomes how. In Wisconsin, we have that peculiar problem of the drafting files becoming public upon introduction. So if I write a drafter's note in the file describing my opinion, and of course it is just my opinion, really, who cares about my opinion? I'm not a judge. But if I write a drafter's note describing my opinion about the problems with the bill, this could be seen as the author as an attempt to undermine the bill. Suppose you could do the same if you're sitting in a committee hearing talking about the problems with the bill, if you're too emphatic about how many problems there are. And that's not really that nonpartisan now, or at least it doesn't look like it. It also puts me in this confrontational stance against the legislator who I'm trying to get to trust me. So perhaps having a conversation would be best. Knowing the audience is crucial on how or when to deliver bad news as well. Again, with my controversial topic, every bill on the issue is designed to push the constitutional boundary. I don't feel the need to bring up the constitutional issue generally, because the whole point is to be questionably unconstitutional and see what happens from there. My oral brief on constitutional jurisprudence would be unnecessary. The authors already know what they're doing. In giving bad news, first you might want to do some research to come up with a way to draft the bill that is safer. And by that I mean maybe there's a way to skirt like a preemption issue, or maybe there's a way to make it less likely that something's ruled unconstitutional without undermining the entire purpose of the bill. And have those ideas in hand to give to the legislator. And maybe if the issue is in one small portion of the bill, maybe you can give them a bill with everything else but that and request a discussion about that issue later. In Wisconsin, we have these dreaded purpose or intent statements that we drafters really don't like to put in bills because they really don't have a legal effect. At least the courts have said so, but people tend to want them. So what I do is I leave them out of the first draft every time so that later we can discuss their inclusion. And then they can tell me exactly why they want it. But then, they have something else to look at, so it's not holding up the whole draft. And when you have to deliver bad news, you can try the sandwich theory, which is to start with the good news, drop the bad news bomb, and then end with the good news, which is so sandwich the bad news between the good. So maybe something like, okay, I think we can fix this, but this one provision might run up against the prohibition against impermissible delegation of a legislative function, for example. Go on briefly if necessary, and then give a solution to help alleviate the problem. If there is no obvious solution to the problem, I return to what FDR said, which is be sincere, be brief, be seated. Chances are the legislator liked their own idea, so being told that it might not work as planned is going to be a little disconcerting. So don't knock the legislator down and repeatedly kick them over it. State the concerns as directly and as briefly as possible. Perhaps, maybe if you feel the need to cite a case to support your point, consider citing as few cases as necessary to make the point. Piling on case after case of why this is unconstitutional may seem like overkill. Maybe just cite the latest case and offer a more detailed response if desired. You can offer to do a more detailed memo, but it doesn't look good for this particular idea as far as the Constitution is concerned. And maybe you've noticed I tend to be direct. So, for example, when asked by one legislator what an impact of a new governmental body would be, and he'd asked this question several times, I kind of knew I needed to emphasize that he was breaking new ground. So I said, this is highly unusual. Now that may have been blunt and direct, but it was effective. He got it, and he asked me more about it the next time we spoke, and he actually quoted my words about being highly unusual to do so. But I think he appreciated the heads up so that he could adequately answer questions in committee. And also, again, I knew my audience. This wasn't the first communication I'd had with him. And I don't necessarily advocate this degree of bluntness, but being clear, direct, and serious when the situation warrants is important. I don't want a legislator to be blindsided by something I see. And sometimes it requires removing the sugarcoating while still not being condescending about it. So I'm advocating for open communication, but keeping an eye to brevity and tone. But of course, there have to be some caveats. We're talking client interaction here, and interaction is a two-way street. So sometimes you shouldn't necessarily act on what you hear. It requires trusting the relationship you've built with the legislator and trusting yourself. Let me talk a little bit about filtering out the noise. And why do I need to do this? I was thinking that in private practice, the attorney writes the briefs and motions, the attorney argues in court, usually makes any statements to the press or outside parties. The attorney really speaks for the attorney-client relationship for the most part in traditional practice. In our legislative world, we draft the bills, but we aren't considered the author. We stay nearly silent in the press, or at least as silent as we can, while the legislator does all of the talking. Sometimes the legislator will say, the legislative attorney said the bill does this, and they'll give us our 15 seconds of fame, but we are otherwise behind the scenes, most of the time because we want to be. That leads to some noise from outside that we might need to filter out to be effective and efficient at our jobs. So the first caveat to communication involves puffery and platitudes. Legislators are politicians. So it's said that they can engage in puffery and, some platitudes. They may say things about the bill that aren't quite 100% correct, sometimes unknowingly, sometimes you don't know whether they knew it was correct or not, which might be a little surprising to the drafter. They may say to the press they're drafting legislation that will do all of these amazing things, much to our surprise, considering the scope of what we believe to be drafting. Or maybe we don't even have the request to whatever they're stating yet. Really? You're drafting that? Why don't I know about that? That's funny. So it may be in some of these situations worth clarifying with the author that he or she understands the bill that you've drafted, without, of course, putting the words that he or she said in the press back, in their face. But otherwise, you may just need to let it go. I mean, if you know behind office doors that you and the legislator were on the same page, the comments in the media as to what the bill does are not really worth chasing down or becoming frantic about it. When I interviewed for this job at the Legislative Reference Bureau, a senior drafter told me of listening to the floor debate when she first started. She said she ran down alarmed to the bureau chief's office stating, "The author just said something wrong about what the bill does. What do I do?" To which the chief calmly but sternly replied, "Nothing." Luckily, that one model rule about professional conduct, about candor to the tribunal, does not apply to floor debates. They can really say whatever it is that they want, and we can do nothing. Similarly, remember the legislator may say something to the press just to get the press to stop asking questions for a while. They might not intend for you to use their statements to the press as drafting instructions. So read the news reports and the Twitter feeds, but think carefully about how you react to them. The other caveat, which I'm calling toughen up, buttercup. In Wisconsin, we have the dreaded drafting error comment. A legislator on the floor will sometimes, when challenged, call an aspect of a bill or amendment a drafting error, much to our dismay and groans, even though the drafter may know that the author fully intended exactly the way it was written, or maybe even never even questioned it before. So sometimes we drafters just get thrown under the bus, and that's just the way it is. Attorneys do too, in private practice. I think of it this way, to make myself feel better and maintain calm, that if I've done to the best of my ability what I believe I've been asked to do in order to effectuate the intent of the author, and if I'm satisfied that in communications with the author that I've accomplished this, then fine. Heave me under the bus in the press or on the Assembly or Senate floor. I get it. It's politics. I understand not wanting to admit error to other legislators and constituents. If I've established that trust that I've been talking about with the office, I know that they really don't mean to blame me, and I know they don't really mean it either. They'll probably call tomorrow, maybe not necessarily to thank me for all my work, maybe more likely to request another bill draft. And here we go again. So I've put my email address up here if you want to throw some electronic tomatoes at me outside of this webinar. And I'll conclude by reiterating this that great quote by Maya Angelou, in the hope that that it is true that people will never forget how you made them feel. I've learned that people will forget what you said, people will forget what you did, but people will never forget how you made them feel. So I will take any questions if you have them.
This is Wendy again, and I don't see any further questions, but as Tammy said, any of you can get in touch with Tammy via email to ask questions if they occur to you later. And thank you so much, Tammy, for presenting this webinar. I'm pretty sure I can hear legislative staff all over the country clapping wildly in their offices. Thank you also to Kay Warnock, who is the Legal Services Staff Section Liaison, and to Tricia Simmons of NCSL. And most of all, thank you to all of you out there who participated today. The webinar was recorded, and NCSL will post it on its website for anyone who wasn't able to join us live today. And I would encourage you to watch for notice of our next Legal Services Staff Section webinar, which is Active Supervision After North Carolina Dental. And that will be on Thursday, January 21st of the new year. Have a great day, everybody.